Good morning, everybody, and thank you, Chair. I am going to speak to you this morning about the public participation provisions in the EIA directives. But actually, I'm going to be even narrower than that. I'm going to speak about two recent decisions that look at very specific parts of the public participation provisions. The first decision I'm going to look at is the Supreme Court's decision on the 1st of July of this year in what I refer to as the Ballysacks and McQuaid quarry cases, otherwise known to people as the Antashka and Sweetman cases. And that decision looks, among other things, at the role and timing of public participation in environmental decision-making as it applies to the substitute consent process for quarries. The second decision I'm going to look at is really actually an opinion of the Advocate General in case C826 of 18. I'm not going to try and pronounce it. Some people call it the pigs cases, but it's the opinion of Advocate General Bobek in a decision that relates to access to justice arising from public participation or other standing provisions in the Dutch National Court. So turning first of all to the EIA directives, I'm going to look just at selected provisions of Articles 6 and 11 of the directives. Article 6 deals with the question of when the public shall be given early and effective opportunities to participate in environmental decision-making procedures. And the provision provides that the public shall be entitled to express comments and opinions on the environmental decision-making procedure when all the options are open to the decision maker and before the decision on the request for development consent is given. And the key point there is the timing of the public participation and when that participation can be effective or when it can effectively influence the environmental decision making. Another aspect of it is also what constitutes environmental decision making. In other words, there are sometimes decisions which involve preliminary procedural steps that don't actually go to the heart of the environmental aspects of the decision. And the question arises in those cases as to whether public participation needs to be provided at that preliminary stage. Articles 6, 2 and 3 deal with the information that is to be given to the public in the decision-making procedures so as to ensure that their participation is effective. Article 6.2 provides that the public shall be informed electronically by notices or other appropriate means of certain matters that are specified in the provision early in the decision-making procedure and at the latest as soon as the information can reasonably be provided. Subarticle 3 refers to the timing and effectiveness of the information given to the public following the decision. And so that includes the information that led to the decision and any analysis provided with it. And the provisions provides that that information is to be given within reasonable timeframes. Article 11 then deals with access to justice or access to the courts. And the directive provides, in accordance with the Aarhus Convention, that access shall be given to the public concerned. And we'll deal with this naming later in the presentation, but there's a distinction given between the public, meaning the public at large, and the public concerned, meaning those who have a sufficient interest in the matter or who maintain the impairment of a right, whose rights are effective, where the law provides that that is a precondition, And these parties shall have access to a review procedure before a court of law or another independent and impartial body. And that is to challenge both the substantial and the procedural legality of the decision in question. This typically involves judicial review to the High Court when it involves challenges to planning decisions in particular. The directive provides that it is up to member states to decide what constitutes a sufficient interest and what constitutes an impairment of a right. And in the Irish courts and in Irish legislation, traditionally a sufficient interest has been established by having an interest in land, for example, an adjoining landowner, or somebody living in the neighbourhood of a proposed development, or otherwise having a right that might be affected by the proposed development. And the Aarhus Convention and the EIA Directive both specifically confer sufficient interest status on non-governmental organisations meeting national rules for that status, or what I'll refer to in this talk as environmental NGOs. They shall be deemed to have rights that are capable of being impaired for the purposes of the directive. So looking at the Supreme Court's decision in Ballysacks and McQuaid, what those decisions considered, among other things, was the role of public participation in the substitute consent process. These are lengthy judgments and they're worth reading in full. Given the time allowed, I'm necessarily going to be extremely briefly dealing with the factual and legal background. But in summary, in the Commission v Ireland case, the Court of Justice found that the Irish provisions that allowed for retrospective planning permission in the form of retention permission to be granted fairly readily was in breach of the EIA directive insofar as projects that require EIA are concerned. The court determined, among other things, that national rules which facilitate retrospective regularisation of EIA projects should ensure that such permissions remain the exception. And from this principle, we get the idea of exceptional circumstances. In other words, a developer should only be able to avail of a retrospective regularisation regime where exceptional circumstances apply. And in response to this judgment and over a series of legislative amendments to the Planning Acts, the Irish legislature introduced 5 routes to retrospective regularisation for projects, not all of which relate to quarries, but all of which involve a 2-stage process. So under 3 of the routes, the planning authority is directly involved. In relation to quarries, the planning authority can issue directions under section 261A of the Act, directing developers to apply in certain specified circumstances. Under section 177B1, a planning authority can issue a notice directing a developer to apply following a quash of a previous planning permission in certain circumstances. Under the other 2 routes to regularisation, On Board Planola is directly involved. These involve decisions under section 177C, in which the developer initiates the application by seeking leave to apply to the board for substitute consent. The developer can do this in 2 circumstances: where there was an invalid permission that was quashed by a court of law or otherwise found to be invalid or otherwise considered to be potentially invalid due to a failure to carry out EIA or appropriate assessment, or otherwise in what the developer would classify as exceptional circumstances. So it is under these 2 routes that the Supreme Court considered the role of public participation. As I mentioned, under the 5 routes to regularisation, the statute sets the conditions by which exceptionality arises under section 2, that should be 261A, and section 177B1. So the statute sets out the conditions under which the planning authority will issue a direction to the developer, inviting them to apply for substitute consent. However, under Section 177C, whereas the statute sets out the criteria, the board is actually who decides whether or not the development satisfies the relevant tests for exceptionality under Section 177D. So the judgment in McQuaid involved Section 1772A. The developer had applied to the to the board for leave to apply on the basis that the previous planning permission granted for the development had been quashed following a court decision relating to the inadequacy of the EIA and AA. But in Ballysacks, which involved Section 1772B, the developer had applied to the board for leave to apply on the basis that exceptional circumstances applied. What is clear is that there's no public participation provided for in the legislation in the process under Section 177C. As the court determined in the judgment at paragraph 108, I cannot consider this as anything other than a deliberate choice by the legislature, given the clear terms in which such participation is provided within the same part of the Act in respect of the application proper. So the court had compared the pre-application stage with the application stage and found that public participation was clearly provided for in the latter stage, but not in the first preliminary stage. The evident legislative intention as expressed in the Act is to the effect that the leave stage is intended to be carried out without a general right of public input. As such, I agree with the respondents that what is intended at the application stage is what has been referred to in these proceedings as a closed process. So the public is expressly excluded from the leave stage. While the consequences of this are discussed below, I cannot see any way of reading in to the statutory provisions a right to participate in the leave stage, given the clear legislative intent to the contrary. So the applicants in this case had argued that even though the Act didn't expressly provide for public participation at the preliminary leave stage, the board ought to have read that into the legislative scheme in order to give effect to the European provisions of the EIA directive, and the court rejected that proposition. The court noted that the granting of leave is quite evidently a prerequisite to successfully navigating the Section 177C and D gateway for substitute consent. It is not a mere technical or box-ticking exercise. Rather, it's a highly significant aspect of the overall process in that the outcome of the leave application will determine whether the application for substitute consent, which itself is an exceptional avenue given the requirements of EU law, can be made at all. The court went on to say that the legislative scheme does not permit these matters, as in it does not permit a consideration of exceptional circumstances or the circumvention of EU law, to be revisited subsequently. The public is therefore denied any opportunity to make submissions on these matters. The court went on to say that the option of refusing to grant leave is off the table by the time the public have any opportunity to make submissions, which may be relevant to that decision. And I think it's useful to pause at this point to say that a two-stage process is not unusual in planning, and it in fact exists for strategic infrastructure development, for example. But the Supreme Court has previously ruled on that in the Callahan case and found that there was nothing really at the pre-application stage for strategic infrastructure which couldn't be revisited at the later stage. All that the pre-application stage did was admit the application to a certain procedure, but it didn't exclude consideration of environmental issues at the next stage. The court in Ballysacks and McQuaid considered the circumstances in which public participation at the first stage of a two-stage planning process might be legitimately excluded. And in this context, I think I've pulled out the following circumstances, and one is where there is a total overlap in the factors which may be considered as between both stages. So in other words, if exceptional circumstances could be considered at the first stage and the second stage, that would be okay. Again, if the decision at the leave stage may be revisited at the substantive stage, provided that all options remain open. In other words, provided that the board could decide, for example, at the substantive stage, that substitute consent is not an option and shouldn't be leave to apply shouldn't be granted, that would be okay. If the public can make submissions at the substantive stage on whether exceptional circumstances exist such that it would be appropriate to permit an application for substitute consent, in other words, if the public can make submissions at the substantive stage that they might otherwise want to make at the leave stage, that might be okay in certain circumstances. And if the matters to be determined at the leave stage are not really matters to which the public may have particularly relevant information, that might not otherwise be available to the decision maker, that might be okay to exclude them at that stage. In other words, if there's certain qualification criteria that only the developer can satisfy, perhaps the public does not need to be involved in that aspect. However, in this case, the court was at pains to point out that the question of exceptional circumstances goes to the behavior of the developer and whether or not they have complied previously with planning permission and the requirement to obtain EIA approval prior to granting permission. And there are circumstances in which that information may be better known by members of the public concerned than by the planning authority or the decision maker. In terms of whether participation can be provided at the second stage of a two-stage process only, the court said as follows: I interpret the directive and the case law as meaning that once all options are open, that public participation in, for example, the exceptionality requirement can take place at either stage 1 or stage 2 of the process provided for under the 2000 Act. The court went on to say then, nonetheless, it might be useful to say that the most appropriate time at which that participation on that event should occur is if, in fact, leave is granted. In other words, those applications which might fail for this or other reasons could be dealt with at the first stage, but then where successful, the issue of exceptionality and the public views thereon could take place together with all other issues upon which the public might have a right to participate at the substantive stage. So this expression of opinion really on the part of the Supreme Court indicates that there's an openness there to participation being provided for at the second stage once the issue of exceptionality comes into play at that stage, and that it isn't strictly necessary that the public should have to participate at both stages of a two-stage process. So, moving on then to the Advocate General's opinion, which is on a slightly different issue. This considers the conditions for access to justice under Article 11 of the EIA Directive. It's linked to some extent to the question of public participation and the stage at which that gets brought into play, because the access to justice is really the remedy that gives effect to the right that's contained in Article 6 of the EIA Directive. And the opinion deals at length with the distinction under the Aarhus Convention and the EIA Directive, and indeed the Industrial Emissions Directive, between the concept of the public and the public concerned. The public is expressly defined in the EIA directives as any natural or legal person and their associations or groups. And in effect, the public can mean the public at large or everyone, but it really does depend on the context in which the term is used. The public concerned then is expressly defined as the public who is likely to be affected or actually affected by the environmental decision, or the public that has an interest in the environmental decision-making procedure. And as I mentioned previously, environmental NGOs that meet the national requirements for such bodies are deemed to automatically have an interest in and therefore constitute the public concerned for the purposes of the directive. What is also interesting in the Advocate General's opinion is the consideration that's given to the rights of access to justice under the Aarhus Convention, and whether that can be made subject to national rules providing for prior participation. So this is an issue that comes up quite regularly in the Irish courts and indeed in the construction of legislation in this jurisdiction. In other words, whether a member of the public concerned, whether a member of the public concerned should be entitled to access to justice merely through prior participation. And the Advocate General said that effectively rules which confine access to justice to those who have participated are inconsistent with the EIA directive, and that there's nothing in the directives or indeed the Aarhus Convention which limits the right of access to justice only to environmental NGOs or those who have participated previously in the decision-making process. EU law does not preclude the exclusion by national rules of access to justice to the public once the public concerned are guaranteed access. In other words, you don't have to allow access to justice to the world at large, but once a member of the public meets the criteria for the public concerned, they should have a guaranteed right of access to justice subject to meeting other procedural requirements that the member state may lay down. Finally, the court, or the Advocate General, considered whether member states may set conditions for access to justice, and the Advocate General held as follows. First, in the eyes of the court, the administrative decision-making on environmental matters and its potential subsequent judicial review are two distinct procedures. Naturally, both procedures share the same subject matter, but they ought to be kept separate. Second, Article 9.2 grants an independent, freestanding right of access to court in environmental matters for the public concerned. The court accepts some degree of connectivity to the public participation procedure, but not conditionality. Third, the national conditions that may reasonably be set in transposing Article 9.2 and thus setting the criteria for access to a court cannot deprive the access itself of its content. And it's in this context that the court appears to have formed the view that insofar as there may be restrictions on parties raising new issues that were not raised at the pre-application or the public participation stage, then they cannot strictly be excluded from the access to justice procedure where the party meets the relevant criteria as the public concerned. In other words, you cannot necessarily prescribe the scope of the access to justice by reference only to matters that were raised before the decision maker in the first instance. So that's all I have to say about those two decisions, and I welcome your questions and any comments you wish to make in our Q&A. Thanks very much.